Let me ask you something. If you are creating contents like writing articles, musics and videos, whenever you are creating it, it is protected by copyright law. But one fine day, a richest company comes, takes away all your content without your permission, without paying you any money, without even recognizing your work, and when you drag them to the court, they give a defense saying that we have used this content only for research purpose and that's fine. This is not a story, this is what exactly happened in India. A few days before, on July 24, 2026, Delhi High Court passed a landmark judgment about copyright on AI. This is the very first judgment about AI copyright ruling, and this judgment has shaken many of the content creators like journalists, musicians, directors, filmmakers. All of them have really taken aback from this judgment. In this video, we are going to discuss about the case of ANI versus OpenAI, and in this case, the landmark judgment was passed. What was the landmark judgment and what as Indians we should do to protect our copyright? Come, let's discuss. Myself Rohini, your corporate lawyer from Intelligensia Private Limited. This case is between ANI versus OpenAI. ANI is nothing but Asian News International, which was started in the year 1971. This company is South Asia's largest news agency multimedia company. Any breaking news you see in Republic TV, NDTV or any other national television on news, ANI is the backup for them. So for Indian journalism, ANI is considered to be the backbone of journalism in India. On the other side, we have the other party, OpenAI, which is nothing but Chatgpt. Today, Chatgpt has become one of the most important apps used by all the members in each house. Today, the company is valued to be more than $300 billion. Now, ANI is filing a case against Chatgpt on the following two allegations in the year of 2024 November. And what was the allegation? It was based on two important points. The number one allegation is ANI has a lot of news journals and articles which is published, and OpenAI has taken away all of these journals from them and started developing and training their AI tool without the permission of ANI. They have not made any licenses, they have not paid any money, and they have not even taken any permission, and they have started utilizing it. The number two allegation is one of the wild allegation. They have claimed that Chatgpt is utilizing their articles and giving fake stories about it, and this is attributing to ANI. And they have also claimed that this is actually giving misinformation about the news which is happening in India. As an audience, you might be using a lot of Chatgpt, and some of the time we have also experienced Chatgpt giving misinformation or imaginated story. If you have experienced any such kind, kindly comment below in the comment box. Now, what happened inside the court hall? This case was actually filed in the month of November 2024, and ANI has claimed an interim injunction to stop the Chatgpt from utilizing any of their articles. But the interim injunction was not so easy. The case went on for nearly 2 years with 32 hearings, and finally, July 24, 2026, there was a judgment which ran for nearly 134 pages. Initially, this case was filed only by ANI News Agency. But later, there were companies who volunteered themselves to be a part of this case, and they were none other than T-Series, Saregama and Sony Pictures. They actually volunteered, stating that their music video, their lyrics in the songs have been copied by Chatgpt, and again they are training their AI utilizing these musics and lyrics. So they also wanted to be a part of this case to fight against the Chatgpt's usage. Finally, in the month July 2026, Justice Amit Bansal gave a judgment which ran for nearly 134 pages, and in the judgment, the important part was he refused to give the interim injunction which was claimed by ANI. The interim injunction was actually pleaded for stopping the Chatgpt from using any of the informations which was copyrighted by other company, but court has rejected it, and they have refused it for the following important reasons. The main reason was that the usage of information by Chatgpt falls under the category of Section 52 Clause 1 Clause A Clause I of Copyright Act. This section talks about fair dealing exception. That means anyone can utilize the information which belongs to another person or company without their permission, provided that information is used only for private purpose or education purpose or for research purpose. ChatGPT's open argument in court was that they have utilized all these information as a part of research purpose to train their AI tool. But in return, ANI news agency argued that ChatGPT is not only utilizing this for research purpose, the outcome is utilized for commercial purpose, and using that they are making a lot of money. But court actually did not consider this argument. They have mentioned that even some of the commercial purpose is considered to be falling under this section 2 clause 1 of fair dealing exception. ANI's second important allegation was that ChatGPT is giving a lot of fake informations and misinformations about the news articles. But about this, the court has mentioned that ANI has to submit proper evidences in order to claim such statements. Why this verdict has really taken a shock for all the content creators. When some company is going to come and take away all the content creators' information and they claim that they are trading their AI for research purpose, and which is a fair dealing, then this becomes a serious problem for every right holders. For example, journalists are sitting and writing a lot of articles, but if some AI is going to summarize that, they get no credit out of it. Somebody is creating out of their creativity a lot of music, and their music is actually copied and recreated in any AI, they will not get any credit for their creativity. So what India must do to protect the copyright of all the content creators? The Copyright Act was passed in the year 1957, and the latest amendment was made to that act only in the year 2012. Now ChatGPT was launched in the year 2022, so it didn't even exist when the amendment or law was passed with respect to copyright. Now our courts are doing our best to somehow protect this law, but here is the good news in India. The DPIIT, the Department of Promotion of Industry and Internal Trade, has proposed a blanket framework license to protect this copyrighted work of content creators. This blanket license framework is for the AI companies which is using the copyrighted content. Whenever an AI company is using the copyrighted content, they have to give a centrally managed fund in order to recognize the creators of that work, and this is not just actually a ban, it is actually a balance for the content creators as well as the development of AI companies. The Commerce Ministry has actually set up an expert panel especially to develop this Copyright Act with the evolvement of AI in the current age. Already European Union countries have started this, UK has started debating it, and India has started right now for the same. Finally, before coming to the conclusion, I would like to tell you one important information. If you are an entrepreneur who are already running a business, or you are starting your business newly, you might need a lot of licenses and registration to run your business properly. For that, we have created a free PDF in which what companies and what businesses have to get different type of licenses, what is their fee, what is the documents have been mentioned. If you want to download that free PDF, in the description there is a link to Google form. Fill in the form and submit it. You will be able to download that free PDF and check it for your businesses what licenses are applicable. Now coming to the conclusion. India is becoming an AI hub for the whole world, and AI development in India is going at a much faster pace. So any intellectual property law like trademark, copyright, patent has to evolve with the fastness of AI age. If you are a content creator of any type, like a journalist, a writer, or a YouTuber, or if you are a filmmaker, then this case is all about your rights, your future, and protecting your work in future. This case of ANI versus OpenAI, this judgment is not the final judgment. There are going to be lots of cases which is going to come because of this AI trained tools. And if you are a content creator and your content is being exploited by any AI tool, don't forget to take any action. If you have experienced any such copying by AI tool, then let us know in the comment box. We will give you what is the legal action you will be able to take in such scenario. Like this, more useful video will be posted in our channel. Don't forget to subscribe to our channel. Myself Rohini, your corporate lawyer from Intelligensia Private Limited.